Justice of the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons have with this before this court, with all everything their attention shall be heard.
Good morning, and please be seated. The first case for oral argument this morning is 794, People v. Samuel Maxwell.
Good morning. May it please the court. I am Sabrina Bremer on behalf of Mr. Samuel Maxwell. There's no dispute that drugs were sold out of 55 Austin Street, but New York law is clear that evidence that the house was used for drug dealing is not sufficient to find Mr. Maxwell himself guilty of unlawful drug or
I think we know that.
So here the facts cleanly track other prior decisions from this court, such as People v. Mighty or People v. Williams or People v. Neitner, where no evidence other than Mr. Maxwell's mere presence in the house connected him to the house.
Okay,
Wasn't there a fingerprint? I'm sorry, go ahead.
Okay. No, there was a trap house, though, correct?
Yes, the word trap house was used and drugs were sold out of the house.
And that
But
was the testimony during the trial.
yes, that was the testimony during the trial. And in People v. Mighty, for example, there was also evidence that drugs were sold out of the house, or in People v. Ponder, which is a weight of the evidence case, but similarly, drugs were sold out of the house, but because the possessions inside the house belonged to people other than the defendant, this court found that the guilty verdicts were against the weight of the evidence. And looking at what possession...
What about the defendant's ID found in the living room?
Sure, so the defendant's ID was in the living room, and I think that goes to presence. The identification card did not list 55 Austin Street as his address, and it is known and not disputed that Mr. Maxwell was at the house when police executed a search warrant.
There was some testimony about the community gun, and it would seem that based on your argument, that a community gun could never be attributed to any one individual unless there's DNA evidence or something like that. Is that your position?
No, that is not my position. It is my position that while a community gun could be constructive possession could be used to establish that a gun was a community gun, the facts don't support that conclusion in this case. In a series of cases, this court found that where a gun was placed on a table in a living room, the house was being used to house victims of a kidnapping, and the defendant was simply in that living room. Those facts were insufficient to find that that defendant exercised control over that gun. And here we have a gun that is wrapped in a towel in a bedroom, and there is no testimony or evidence suggesting that Mr. Maxwell was a resident or a regular occupant of that house, or that he had knowledge of that gun.
He was taking a shower upstairs, and then easy access, correct? Isn't that true? Isn't that what the testimony was?
I'm not sure that would be easy access. He was in the upstairs apartment, which was a staircase away from the downstairs bedroom where the gun was found. There was also a BB gun that was in the upstairs apartment where there were multiple other adult tenants, and there was no testimony introduced at trial as to who that gun may have belonged to.
We'll look very carefully at all this.
Okay, just briefly on sentencing, if this court affirms Mr. Maxwell's convictions, a reduction to reduce the disparity between the sentence imposed on Mr. Maxwell as opposed to the one imposed on Bishop DeLoach is appropriate here. It is undisputed that the house belonged to DeLoach. If one looks at the photographs of the house, the word trap house is used, but it was also his primary home. The photographs show that there was clothing, that there was food in the cupboards. DeLoach appears in photographs in the home. His social security card, birth certificate are all there. That was his home. He may have sold drugs out of that home, but it was also his residence. Okay, if there are no further questions, I will rest.
Thank you.
Thank you.
Good morning. May it please the court. Bridget Field on behalf of the people. The evidence here established more than mere presence. It was a trap house that was very, very clear from all the testimony, from even the observations within the house. The door was barricaded. Mr. Maxwell was found upstairs taking a shower. So Mr. Delos's testimony was that he was permitted there just to be watching TV. He was taking a shower at 5 o'clock in the morning. There was evidence that the upstairs apartment had been broken into. The door was, there were fresh, if you look at the pictures, I think it's pages 189, 190-ish of the record, there's pictures of the door to the upstairs apartment that looked freshly broken. There's blood on the floor. There's blood on a sweatshirt. Mr. Maxwell and Mr. Karen, who was, I'm not sure how to say his name, but Karen James, I apologize, both of them had cuts and abrasions. Something else was going on in that house and then two men sitting watching TV. The fingerprint was on the bottom of the plate that drugs were found on. There were drugs in numerous locations in the house.
Can I jump to the gun?
Of
The gun
course.
issue, I mean, the case that the council was citing was Roldan, the one with the gun on the living room table. We have People v. King in the briefs. We have Diallo. King, there was DNA on the gun, and that still wasn't sufficient because it wasn't being used at the time. How do you distinguish those cases?
Here, I think the evidence that this was a trap house and what was going on in the house, and despite the testimony that Mr. Maxwell had permission to be there to watch TV, it's clear that that's not, he was doing something else. Again, the abrasions, the blood, the shower. I think that it was very reasonable for the jury to find constructive possession based on those factors. The gun was wrapped in a towel, but it wasn't in a safe, it wasn't in a drawer, it wasn't hidden in the back of a closet. It was merely wrapped in a towel. So I think that there's enough factors of all of the circumstances present in the house to come to the conclusion of accomplice liability or constructive possession for the gun.
His fingerprint was found on a plate, wasn't it?
Yes, it was on the bottom of the plate that drugs were found on, I believe in front of the TV, although I'm not positive of that. And his ID was found in the apartment. The defense counsel makes mention that there's no evidence that he lived there. Well, the evidence was very clear. It was a trap house, which typically does not have a single resident, and that there are plenty of people through the house. So the fact that he didn't live there wouldn't be, I don't think, is enough to go against the implication that he was aware of what was going on in the house.
Thank you.
Thank you.
796, People v. Walter Morse.
Justice Smith, excuse me, may it please the court. I'm Drew Dubrin on behalf of Mr. Morse. During Mr. Morse's plea allocution, Mr. Morse cast substantial doubt upon his guilt of criminal possession of a controlled substance in the third degree by expressing that he was sticking to the statements he had made to police officers shortly after the incident. Because he raised such substantial doubt, Mr. Morse's guilty plea cannot be found to be knowing, intelligent, and voluntary without the court having conducted further inquiry. As this court's holdings tell us, Mr. Morse's statements must be viewed in their entire context. How the prosecutor described the alleged conduct and what Mr. Morse admitted to and what he refused to admit to as to the conduct described by the people. As this court held in Peoples versus Bovio, to the extent that there is equivocation, that itself warrants further inquiry.
Does it matter that he never protested his innocence?
I think he did with respect to the question of intent to sell. He did. He indicated that he was sticking to or standing by the statement he had made to police that while he had possessed the drugs in his house, that he had sold drugs in the past, as the prosecutor had said, he expressed no present or future intention to sell the drugs. Again, we have to look at, yes, Your Honor.
The plea, it looked like the court went through that with some care, took 2 breaks, let counsel talk to him about it, went through it very carefully. At one point, the prosecutor had corrected the record, made it clear that, no, you didn't make the admission that you intended to sell, but that's part of our claim. Why isn't that sufficient?
Because by refusing to admit to the conduct described by the people, again, viewing the allocution holistically, as you would suggest, Mr. Morse was expressing that he was sticking by or standing by the statement he had made by the police, which indicated he did not have an intent to sell. And then it wasn't until, you recall, it wasn't until the people modified their description of the conduct to correctly describe what he had told the police that he then admitted to the conduct described. To your point, Justice Nowak, the question is, why isn't that a sufficient inquiry? Perhaps that's what you're suggesting.
Right.
Because the court never told Mr. Morse, and that was his obligation, that he had negated an element of the crime. And then, to the extent that there was equivocation, clarified whether, in fact, he had the requisite intent. Indeed, in this regard, this case is different from People versus Shaw, where, although the defendant initially negated the element of intent, there was a discussion off the record with counsel, and then the court and the prosecutor asked the defendant straight up whether he had the requisite intent. And then the defendant very clearly admitted to having the requisite intent. But this is very different here.
Well, didn't the DA here make comment that the evidence would show that the quantity of the drugs and the presence of drug paraphernalia, that goes to intent?
That would show that the people had evidence to present at trial that would demonstrate intent. But again, we must look at the allocution holistically, and he refused to admit that conduct as described by the people until the people modified their description of the case. Until they said, yes, indeed, Mr. Morse had, in effect, denied intending to sell the drugs he had in his alleged possession. That he admitted to possessing those drugs, but he did not admit to a present or future intention of the drugs, which conveyed that he did not have the requisite intent.
Yeah, I think we understand that issue.
And again, as this court has recently held in People versus Bovio, to the extent that there are contradictory statements, that warranted further inquiry. Moving on to the second point, Your Honor. The court either abused its discretion or improvidently exercised its discretion in denying Mr. Morse's motion to withdraw his guilty pleas based on some evidence that he did not commit the attempted murder, the top count in which he was charged. The court both applied the wrong standard in passing upon the motion, and the record fails to show that the court weighed the competing state interests, which is required for sound exercise of discretion.
Didn't he admit to shooting the victim in the allocution?
He did admit, but as Chief Judge Wilson indicated in his dissent in People versus Tiger, we know that guilty people sometimes plead guilty. And he had strong incentive to plead guilty to attempted murder in the second degree because it was part of a package deal in which he would not get any additional time if he pleaded guilty to this particular crime. Furthermore, Mr. Morse admitted to the described conduct not by giving a description of the conduct in his own words, which would reliably establish his guilt. Instead, he gave a one-word answer to the people's description.
This court has upheld those one-word answers as being sufficient.
That's correct. However, this court has also said over and over again where a defendant has presented some evidence of innocence, in which Mr. Morse indeed did in this case, that the court is empowered to exercise its discretion to allow a defendant to withdraw his guilty plea. Notwithstanding that the defendant had pleaded guilty, if, Your Honor, to your point, if indeed the mere pleading guilty or admission of the conduct would itself be enough, then this court would not have stated over and over again that a defendant should be permitted to withdraw, or may be permitted to withdraw his guilty plea when presenting some evidence of guilt. So I would submit that his guilty plea does not belie his assertion of innocence in these circumstances. Indeed, Mr. Morse's motion to withdraw his guilty plea was not based upon some sort of unsubstantiated claim of innocence. Instead, he pointed to real evidence that he may not have been guilty.
Are you talking about the 9/11 calls?
We're talking about the police dispatches, the 9/11 call, both of which showed that, that 3 people were involved in the incident, none of whom matched Mr. Morse's description. We had a description that matched the victim Coles, a description that matched his friend, Mr. Terry, and a description that matched a light-skinned Hispanic kid who was seen fleeing from the scene and who police believed to have discarded a gun.
And where did that go to those prospective witnesses' credibility then?
It does. It's evidence of innocence, and as this court has said...
But Mr. Morse basically weighed all of that in determining on entering to his guilty plea.
Your Honor, I would suggest...
That's what they usually do. I mean, I have an offer. I think you haven't indicated it was a package deal. You know, if I don't admit to this shooting, I may not get my package deal. So he basically balanced the pros and cons of going to trial and attacking the credibility of these witnesses.
That is true, but we're not contending here that there was new evidence, newly discovered evidence. What we're saying here is that there was some evidence of innocence, which he pointed to. And as this court said, that where a defendant merely makes a conclusory claim of innocence, that certainly does not empower a court to grant a motion to withdraw a guilty plea. But where a defendant has presented some evidence of innocence, the court is empowered to
I think we understand that.
All right. Just two quick points, Your Honor, with respect to the court's exercise of discretion to show that this court need not defer to the court's finding. First of all, the court applied the wrong standard. We know that the court applied, in this case, the standard that applies where a defendant challenges a verdict or a judgment after the judgment of conviction is entered, pursuant to CPO section 440-10-1H. It referred to the defendant's claim as a collateral attack on his conviction, which in fact it wasn't. It was a motion to withdraw his guilty plea, and it determined that the defendant had not proved his actual innocence, which, as we know, is not the standard here. Second of all, the record fails to show that that the court did the balancing that is required for sound exercise of discretion. While the state does have an interest in finality of a conviction, there is no showing here that the people would have been, in fact, the people don't contend that the people would somehow be prejudiced by allowing Mr. Morse to withdraw his guilty plea very shortly after the plea had been entered. So under these circumstances, where there is evidence, some evidence of innocence, it was abuse of discretion, or at least an improvident exercise of discretion, or not allowing Mr. Morse to withdraw his guilty pleas. Thank you.
Good morning, Amy Wallensack on behalf of the people. I'd like to briefly address defendant's point 1 with respect to the plea to the criminal possession of a controlled substance. Here, I would like to draw the court's attention to its recent decision in Romanowski. I think that case is squarely on point for explaining why this particular issue is unpreserved. Defendant did not move to withdraw his plea to the criminal controlled substance count of the indictment that he pled guilty to, and the prosecutor is the one that made these statements. And again, I would like to draw the court's attention to the fact that they're not disputing the amount of cocaine or what he did. This was a dispute about what defendant said to an investigator that day. And I don't think that the prosecutor's clarification of the contents of defendant's statement in any way negated an element of the offense that he pled guilty to. The colloquy that he agreed to engaging in the conduct still noted that the amount of cocaine and the drug paraphernalia located next to the drugs evinced his intent to sell, and I believe it was one sentence before the content about the statement to the investigator that the prosecutor required him to admit that he not only possessed them but had the intent to sell. So I think altogether that particular colloquy adequately laid out the elements. And I believe it was Justice Noack, you pointed out, the court took some care after the clarification was made to ensure that defendant knew what he was admitting to. With respect to the attempted murder count, this was not some evidence of innocence. Justice Montour, I completely agree that this was a defendant who misapprehended the quality or the evidence that was against him. The 911 calls show that this is multiple people that saw various aspects of a very chaotic scene. I mean, I think one of the 911 callers seemed to imply that the victim had been the shooter, which most likely was not the case. I don't think he shot himself, but so at most this would have been mere cross-examination evidence at trial. We have a victim that identified the defendant as the shooter, and this would have been mere credibility issues presented for the case. Unless the court has any further questions, I'll rely on my brief.
Just the last 2 points that counsel raised in terms of applying the wrong standard and not doing the proper balance. You could touch on that.
I don't recall the exact wording that the court used in the decision. I do remember the abuse of discretion, but I think that even if this court were to analyze the decision under the proper abuse of discretion standard, I still don't think that we get to an abuse of the court's discretion. While I recognize that this plea did it took place close in time to when trial would have gone, that's not the only issue that we have to look at. Otherwise, any defendant would, be automatically entitled to withdraw his guilty plea simply because it's close in time to trial. I think when you look at the reason why he wants to withdraw it, that does not entitle him to withdraw the guilty plea with respect to the 911 calls and body cam footage. Unless there are any questions, thank you.
798 people v. Timothy Anderson.
Good morning, Your Honors. May it please the Court. Cleo Weiss for Timothy Anderson. I'd like to begin with the point about the sufficiency and weight of the evidence. And preliminarily, this case presents a question about the standard of review to be employed by this Court. Specifically, this appeal asks whether this Court, when conducting weight of the evidence review, may consider evidence which was never published at trial, was not made available to the jury during deliberations, and which we know from the record was never viewed by the jury. This Court should hold that when we know with certainty that the original 12 jurors never saw evidence, such evidence may not be considered by an intermediate appellate court sitting as the 13th juror and conducting weight of the evidence review. Such a rule would accord with the Court of Appeals' many decisions construing weight of the evidence, and I'd like to highlight some parts of Danielson, Bleakley, and Romero.
Is weight of the evidence preserved?
A weight of the evidence claim need not be preserved by a defendant. It is a unique feature of the intermediate appellate courts in New York State that they can conduct this intensive factual inquiry and sit as the 13th juror. As to legal sufficiency, which does need to be preserved, that is preserved in this case, but as Danielson instructs us, even when legal sufficiency is unpreserved, weight of the evidence, this special review that this court can conduct encompasses examining whether each element of a crime has been proven beyond a reasonable doubt by the people. Danielson also tells us basically that this court sits as a 13th juror and it decides what facts were proven at trial. And all of these Court of Appeals decisions, the real focus here is on the original jury members. When you read these weight of the evidence decisions, everything is framed in terms of what is presented to the original 12 jurors.
So we shouldn't be considering anything about the lighter, the buying of the bottle of water, or the blocking of the doorway and then being corrected, because that was video that wasn't shown.
That's correct. That's my contention, is that when this court is reviewing the evidence, it needs to limit itself to the evidence that only those original 12 jurors saw. Just as in Danielson says, we weigh the evidence in light of the elements charged at trial. Even if the law has changed between trial and appeal, we don't look at it with the current law. It's the same thing. We have to use the same law that the original 12 jurors had, and we have to use the same evidence that the original 12 jurors had.
Jurors did see him pull out the gun on the sidewalk, as opposed to just possessing it in the convenience store.
So that's incorrect, Your Honor, and what I want to clarify there is what we mean by sidewalk, because you have a gas station, and the gas station encompasses the pumps and a convenience store. It's all one business, and the sidewalk is used in a couple ways. Sidewalk could be used to mean the curb between the pumps and the convenience store, like the curb.
Regardless, it was outside of the convenience store and the gas station, outside the business. possess the gun outside the business.
I would disagree with that, Justice Montour, because he's standing on the curb outside the convenience store, but that is part of the gas station. The whole gas station is that parcel where the pumps are. So he is in between the gas pumps and the convenience store, and that is the business, because it is one business.
So it's not the business outside the pumps and the sidewalk or the street?
So
That's not business? He's still outside the business, regardless if it was in between the business and the gas pumps or outside the gas pumps.
So if he is outside the gas pumps, if he is on the sidewalk, say between the street and the gas
He's not in his
pumps.
home and he's not in the business. So
But-
he's possessing a weapon.
Your Honor's view there seems to constrict the definition of the business to the convenience store itself.
I think we understand that what you're saying the pumps and everything, that's a business. And Justice Montour, I believe, is saying, no, it's the convenience store, and that's something we have to look at, but we understand the
Absolutely.
argument.
But, and the last part I'd like to clarify about that for the court is that the part of the evidence that was shown to the original 12 jurors shows Mr. Anderson right outside the gas station on that curb in between the pumps and the convenience store. And the part of the evidence that was never shown to the original 12 jurors is apparently some part of the early footage, again, never displayed, that shows him on the sidewalk approaching the gas station. So that was never seen by the jurors. The only part that's seen by the jurors is Mr. Anderson standing outside, directly outside the doors of the convenience store. And what I would ask this court, unless this court has any further questions about the procedural point, I'd move on to the substance of it. What I would ask this court to ask is, what about this video of Mr. Anderson tells us that he's not the owner of that gas station? Because to me, it's absolutely normal for an owner to spend time at their business, to talk to their customers, to be there. And that's what he's doing. He's drinking some water, smoking a cigarette, speaking with other customers there. And I'm not sure what about that footage would inform us that he's not the owner, that he's not the manager, that he's not otherwise a principal operator, using the test from Wallace, of that gas station and convenience store. And the people could have done something very simple. If he indeed was not the owner or not a worker there, they just could have called somebody who did own the store or who did work there and asked, does Mr. Anderson own this store? Does Mr. Anderson work there? The answers were no. They would have easily satisfied that fourth element, but they have presented zero direct evidence of that fourth element. And I believe that if you consider the video to be circumstantial evidence, I just don't know what's in there tells us that Mr. Anderson is not the owner of the gas station.
Anything further?
Yeah, one last thing I'd like to say on that point. There is an inference to be drawn from the video, and again, the portion that was actually published to the jury, that Mr. Anderson does have a greater connection to the store than other people. At 5:20 a.m. and 17 seconds, you see the store's other cashier open the door, and he shoos other people away from the door and holds the door open for Mr. Anderson to enter. So there is some greater connection that Mr. Anderson has to that store than other customers who were there at the time.
Look at that very closely.
Thank you, Judge. And if this court did not reverse and dismiss the indictment on the basis of the weight of the evidence review, I'm also asking this court to reverse and grant a new trial based on the challenge to the jury panel. And the Sixth Amendment right requires, as we know, an unbiased petit juror chosen from a jury pool that's reflective of the community. And Sixth Amendment jurisprudence has created what we could call the fair cross-section requirement. The people oppose this claim on procedural and substantive grounds as well. There's no questions about the procedural points and the timing of the motion. I'd move directly to talking about the merits of that motion. So as to the merits, the Supreme Court has given us what you call the Duren test. It's a three-part test. The first part of that test is undisputed, distinctive group. The second part of that test is representation that is not fair or reasonable in relation to the number of such persons in the community. And the people raise a number of...
Why don't you go to the third prong?
Go to the third prong? So the third prong is that underrepresentation of a group, which was established here, there's an absolute disparity of 11.2%, that this underrepresentation is due to systematic exclusion of the group in the jury selection process.
And isn't that your problem here?
I think that's actually not my problem, but I think that's where we can win here. This is an interesting case because we have the commissioner of jurors actually give testimony. We don't see that very often in these types of cases. And essentially, the system that he's doing, which is the same system that he was using pre-COVID, there's an omission there. He has not adjusted his system to account for incredibly novel circumstances. The global pandemic, the modern jury system in my lifetime, in all of our lifetimes, has never seen a global pandemic before. And I think that something had to change. It was a dramatic time period. It was dramatically affecting people. It was affecting people in different ways. As we know in articles published in September 2020, as the Commissioner of Jurors acknowledged, this was a disease that had a disproportionate impact on different communities and on different races in our community.
Doesn't the Commissioner of Jurors have to believe, or have reason to believe, that people of color are more scared of the pandemic than people that wouldn't be considered as people of color? Doesn't that have to be established, and was it here?
Well, so the Commissioner of Jurors acknowledged that he was aware of reports that there was a disproportionate impact. But even if he personally was unaware of those circumstances, when we know that those circumstances existed and yet he made no change to his system, that can raise a question of essentially doing nothing, the omission of not making the adjustment that was necessary in that time period is the process that creates the systematic exclusion.
We'll look at that very carefully.
Under Duran.
It's an interesting argument.
Thank you. Unless the court has any other questions, we're also asking for a sentence modification if this court declines to reverse a 10-year sentence for peaceful possession of a firearm in public. There's no aggravating circumstances here. There's no disqualifying factors shown. We've seen the footage. Nobody was alarmed by the fact that Mr. Anderson had a gun, apparently.
You got an enhanced sentence because you're a second violent felony offender, correct?
That's correct. We asked this court to consider reducing it to the minimum of 7 years because this is truly a peaceful possession case.
Thank you.
Thank you, Your Honors.
Good morning. Marty McCarthy for the People. I actually will start with, go back to point one. With respect to the two videos that were admitted, they were admitted without qualification. There was no objection to the entire contents of that disc being admitted, and on appeal, there was no qualification as to, in the stipulation to the record on appeal, the contents of those videos being presented to the court. So the contention, I'm sorry.
From your view, is it on the gas station property when he pulled the gun out outside?
Well, when you consider whether, is it on the property, it's on the parcel. He's on, if you look at it as a parcel, he is on the parcel of property that consists of the gas station. The question becomes whether outside the store is considered inside your home or place of business. And I would submit that it's not, because he's literally outside the business. So taking nothing else, taking none of our other arguments with respect to the other, his lack of connection to that gas station and not knowing the presence of the lighter and the other things that were going on in the video, in the portions of the video that the defendant disputes now. He's literally outside the building, and being outside the building is being outside your home or place of business.
And most of the time when I pump gas, I don't go in the building. I mean, they're conducting business when I go to pump gas. I never go in the building. You do everything right outside now.
Correct. And at the same time, you don't see the employee stays inside the building. The employee doesn't come out and pump gas.
Right.
So that's sort of a reciprocal relationship, if you will. And at 5 in the morning, you talk about circumstantial proof. 5 in the morning, the jury, a trier of fact, can look at that and say, there's no reason why there'd be more than one employee at this business at 5 in the morning. So there are no other questions about point one. I'll briefly address point two. Point two, the people argued on appeal that procedurally the motion was defective. And the reason why we argued that was it was clear from the method of jury selection here that what they received initially was only half of the veneer, not the entire veneer, because of space limitations. And some of you may have been in the trial parts at the time. Actually, I'm not sure if that's true. I think Justice Nowak may have been in the trial parts at the time, where there were space limitations and there were a certain amount of people that would be allowed in the courtroom. Here, it wasn't the entire veneer, it was only half the veneer. Because it was only half the veneer, we have no information about the other half of the veneer. We have no idea what the racial makeup of that. In fact, not only do we not know what the racial makeup of that portion of the veneer was, the defendant did not make another Batson motion with respect to the second veneer, which tells me that there was at least 14.2% of the people there, because otherwise he would have made another motion. But we don't know if there was more. We don't know if there was 30. We don't know if there was 50. We actually don't know. And because we don't know, and because it was the defendant's obligation to make that record, that's why the motion was procedurally improper.
The defendant may argue that they have to make the motion at that time, when the first veneer is there.
The first half of the veneer.
I agree.
You
Can't wait for the second.
I agree that he has to make the motion when he turns around and he sees 3.1%. But that being said, he has to make the record regarding the entire veneer, so that motion has to continue. So he didn't do that, and that's procedurally improper. We don't know what the makeup of the entire veneer was. So this claim could be entirely meritless because the entire makeup of the veneer could have been 50%. We just don't know. And then going back to the substance of the motion itself, the one thing that the defendant doesn't posit is what could the commissioner of jurors have done in this scenario without breaking the rules of requiring random selection. It seems to me that the only way the commissioner of jurors could have done anything would have been to break the rules of random selection, because there's two random selections that occur. There's the random selection of the people who are eligible for jury service. I think he said the number was 10,000 or 16,000. So there's the first random selection of those individuals, and then there's a second random selection that occurs once the entire panel was called. I think he said he could call up to 800 people to assign them to a particular court. So there's two random selections in that scenario, and without breaking the requirement of randomness, I don't think there's anything that the commissioner of jurors could have done, because again, in terms of the sources in which he polls for jurors are appropriate sources to poll for jurors in question. I don't know what else he could have done without breaking the requirement of randomness. Is there no other questions? Thank you.
799 Rotundo versus Deptola. One more person. Do we know if there's a problem?
Your Honor, he is in. He just is not turning his video on.
Can he hear us?
I believe so.
Okay. Was there? Oh, thank you very much. Mr. Kaminsky?
There he is.
Oh, there you are. Okay, thank you. Go ahead.
He's muted.
You have to unmute yourself, Mr. Kaminsky, and then you can go ahead. Great. Proceed. Can you hear us?
Sorry.
Okay, go ahead.
I didn't hear if you were asking for the appellant or for me to.
I'm asking for you.
Oh, I'm so sorry. I had a little bit of difficulty there. In any event, judges, may it please the court, My name is Ed Kaminsky. I was AFC for 2 of the children in this matter. The transcript of the trial testimony below says it all. Throughout the proceeding, the appellant mother was belligerent, argumentative, hostile, uttered vulgarities and obscenities to the court, stormed out of the courtroom. She displayed her hatred towards the respondent father. There's no way whatsoever she was ever going to co-parent with the respondent father. She made that abundantly clear. The parties here were divorced pursuant to the divorce decree, which stated that the children would remain in the Frankfurt School District. But before the Supreme Court judge even signed the divorce decree, the appellant filed the modification petition in another county, which was summarily dismissed. Then she filed several other modification petitions in another county, asking for the same thing. Those were all dismissed. But she got sick of losing in another county. She filed in Herkimer County, and we have this instant proceeding. The reason we have this instant proceeding is because Sir also filed his petition for sole custody. The parties just could not get along. The testimony at trial showed that the mother often left the children alone, unattended. On one occasion, a 5-year-old was outside playing early in the morning with nobody watching her. The appellant mother, on one occasion, was pinned one of the children down on the floor and was restraining her and abusing her physically.
We know all those facts.
Okay, so in any event, Judge, one of the other contentions of the appellant was that as AFC, it was inadequate representation of the children. For the court's information, I met with the child, Giovanna, twice during the proceedings below. I met with the child, Bryn Lee, once, and only once because the other time she was sick. She was sick repeatedly. I don't know if she had COVID or if she was just had a flu. But I also met with both kids after the filing of this petition, after the filing of this appeal here. It's clear throughout the proceeding that that there was only one outcome the court below could have made, and that was custody to the father.
What's the status of the children now, Counselor?
Oh, right. That's the good news, I guess, because right now, I should be having problems after all these years with virtual. Anyways, right now everything's going fine. It's unbelievable. It's the parties are civil with each other. There's no problems. The father actually gives the mother more time than the order provided for. The kids are happy. Everything's going smoothly, beautifully. So there's no reason to disturb the apple cart right now.
Thank you very much.
Thank you.
Mr. Earhart?
Yes, thank you. May it please the court. Brian Earhart, I represent the other child, Mariana Rotunda, the eldest of the 3 girls. With respect to Mr. Kaminsky's statements, I would just note quickly for the record, the procedure was stated backwards. The proceedings initially had taken place in Herkimer County, and there were attempts by the appellant mother to file multiple modifications in Herkimer County. It wasn't until one was dismissed, I believe in May of 2021 by Judge King, that she then subsequently venue shopped and filed a petition in Oneida County.
So there are no proceedings pending currently, correct?
There are not.
And you're in agreement with Mr. Kaminsky?
I am, Judge. It was a very uncomfortable trial. The number of times that Judge Flemma needed to redirect or chastise the mother was quite remarkable. The hostility was palpable. The thing that I would highlight that Mr. Kaminsky didn't address, at the conclusion of the proceedings, the court did offer each party an opportunity to speak about what they wished to have happen. And with respect to my client, the appellant was very direct, indicating that she was agreeable to Mariana residing with her father, remaining in the Frankfurt School District where the children had always attended. There was a large amount of testimony about the bonds and relationships that the children have, how close they are, which I think was a large factor in
Judge Flemma's determination that the siblings should not be separated either.
Thank you. Excuse me. 800, James Caputo, MD versus Richard Tubiolo, S. Judge Noack is recused in this matter. Excuse me, sorry. Go ahead.
If it pleases the court, thank you, Your Honors. My name is James Richard Caputo, MD. I am here on appeal concerning a malpractice, legal malpractice case against the defendants. It's a case basically rooted in evidence and application of the law.
That's what most cases are.
I know, but this is why we're here. The lower court threw out the case on motion for summary judgment and dismissed the case.
Just so you understand, we understand all that.
Yes.
So you gotta go right to your argument.
Okay, yes. So the court had no legal basis to disregard 103 of my exhibits that were submitted as part of my case. My brief describes the nature of how those exhibits turned out to be somewhat missing in this case. It's not clear as to how that happened. But the court really has a duty to the evidence, and in a summary judgment case, they have even a greater duty to the evidence to ensure that there is or is not a triable issue of fact. And in this case, there are so many issues that are either triable or outright in favor of my
Wasn't it your
argument.
responsibility to make sure that those documents were properly uploaded into the system?
I did. I spent an hour and a half that evening uploading them.
Apparently, they were not uploaded properly then.
I had 3 occasions where the system actually asked me to correct 3 of the documents, and I re-uploaded them and they were approved. So how it went from me uploading them to them not registering with the system is still a mystery. I tried inquiring to the court and they had no answer for me. But the important point is that as soon as I uploaded my documents, my exhibits, I emailed them to the defendants as part of a secondary service of documents. And so they had the documents right from the very beginning. They were never prejudiced whatsoever. The court should have at least asked where are these 103 exhibits that I made 340 mentions to throughout my brief, throughout my cross motion for summary judgment. So the fact that they were disregarded is a problem here, because it is a large portion of my case and it would immediately undermine any notion that the opposing party had a prima facie case. Just on the issue of whether there was an attorney-client relationship, which the court ruled there was not one. In my paper, I gave several different examples as to actions by the defendants that justified and established that relationship, as well as in my exhibits, there were additional pieces of evidence, including a billing statement, a professional services statement to the insurance company by the defendants, showing that they were busy and billing hours on the days in question, which was May 19th, 2014. So these exhibits and
May
these...
19th, they indicated they had discussions with you, but they weren't able to meet with you until the next afternoon.
Well, meeting with me and retaining me are two separate things. They never produced their...
They did not take you on as a client until the 20th.
That is not correct, Your Honor. They were acting as my attorneys on the 16th when they were billing hours.
On the 20th, didn't the record indicate that they contacted the ALJ to look at the possibility of an extension because they were still considering whether or not they're going to take you on as a client?
No, they never contacted the ALJ about any extension whatsoever. That was never part of any of this interaction here. We talked on the 16th of May. I sent documents on the 18th of May.
You sent to the OPMC requesting an extension.
No, they didn't actually request an extension.
Indicating that they were determining if they were going to represent you. So they still.
That's their
at that
answer
point
to
in
the
time-
charge of malpractice, yes.
So at that point in time, they still did not have you as a client. And you were aware of the fact that you had to have your answer in by the 19th. Otherwise, there's a possibility that you would be in default and all those allegations would be admitted.
It is not true that I was retained on the 20th, that I retained them on the 20th. No, their actions on the 19th clearly established the fact that they were acting as my attorneys by sending my private information to other attorneys, recruiting other help to assist them.
Still at that point in time, no one's indicated, yeah, we're going to take this on. I mean, there's information that's being sent from yourself or the insurance company to various attorneys. Is anyone going to take this client on? Still hasn't
That's just not correct, Your Honor. That's not the actions that they operated under.
Okay.
They forwarded my information, and every single aspect of the law that establishes an attorney-client relationship, they participated in. And in addition, even if I'm a prospective client, when I sent them the email on May 19th and said, listen, I have the answer pretty much ready, should I submit it or should I wait to see you tomorrow? He had an obligation to me as even a prospective client to say, oh, you should get that in because I'm operating under the assumption that he's my attorney now and I'm going to take his advice. And what he did in response, he said, no, hang on to your stuff, bring everything with you tomorrow. And I trusted that that was something that he felt was legitimate to do. And he even admitted in his own testimony and deposition that he always gets an extension every time he asks for one. In this case, he didn't get one. So again, it's the evidence is very clear as to their actions. I mean, on top of it, when we met on the 20th, there was no retainer signed, there was no written agreement anywhere that they can produce to justify that 20th was the date in which they started representation. It's just not, it's not true.
Well, we'll
And
check
then-
all that. We'll look at that.
in addition, as soon as the meeting was over on the 20th, after I'm told that they're going to defend me and they're going to represent me, he immediately calls the prosecuting attorney and sets up a surrender of my medical license, which was completely not on the table. It was never anything I would have ever agreed to. But yet he did that and never told me about it. On top of it, I got a default letter from the prosecutor the very next day saying I was in default, and not once did my attorneys ever tell me about that. So I'm operating under the impression that, okay, I got my answer to them, everything's all A-okay. A week later is when the hearing is supposed to be, and then the day before the hearing, I get this bomb dropped on me that, hey, you're in default, and now you're no longer going to have your day in court, and now it's at a penalty phase. And I'm like, what? What are you talking about? When did this happen? Is that the standard of care for a lawyer to not tell their client that?
Okay, we'll look at that very
Well,
carefully.
that's what they did. They did everything. Every single thing I've mentioned in my argument and in my papers has been not only substantiated by evidence, but they have no answer to any of it other than taking all of the charges in 2014, blowing them up, and just repeating it over and over. No attorney-client relationship, no attorney-client relationship. They repeat it, repeat it, repeat
We
it.
understand.
Okay, so,
Why don't you wrap up?
I'm sorry?
Wrap up?
Okay.
Because we understand your argument. It's not, I'm not.
I understand, okay. So the bottom line is this, there's so much information in this case that for the court to have granted a summary judgment and dismissing the case, they went way past the duty to the non-moving party. The non-moving party is supposed to be given every deference, and if there's 103 exhibits, they could have asked, where are these exhibits? They could have said, well, had the other side gotten them? And they did get them. And no one was prejudiced. There was no delay. They should have entertained them. And had they entertained them, they could never have reached the conclusion that they reached in dismissing this case. And lastly, there's just a couple documents in evidence that did make it into evidence that really helped substantiate my case, and that is the February 9th, 2011 letter that I wrote to OPMC regarding the charges that they were bringing in 2014 on cases from 2007. And every one of the issues that they were trying to raise were put down in that letter to the extent that they sat on these cases for another 4 or 5 years before they finally had something against me where I inadvertently violated my probation. It was something that I did not realize that was a violation. Every provision of my sanction and discipline through the Office of Professional Medical Conduct was adhered to. I had been compliant with everything. I had not deviated from any of what they had asked me, except I just overlooked the point that writing a few prescriptions would have been a violation. I had an office that was set up and ready to go that I purposely did not reopen in compliance. The cases that they try to use against me, the other side, is they use cases, for example, the case of Dr. Casanova. There's two arms of that case. The first half of that case clearly justifies that my probation violation should have only brought a 6-month extension to my probation because it was very nominal, it was unintentional, it was unwillful. And that was essentially the consensus of the hearing committee on his ruling. However, he decided to appeal that, and in doing so, the appellate division brought up the fact that he was in gross violation of every other portion of his compliance with OPMC, and therefore they took his license away. And that is nothing, that is not anywhere near anything that applies to my case.
I think we understand.
So again, so when you look at the case, we had established attorney-client relationship. They clearly, 3 separate occasions, they were asked about the answer. They even were sent the answer on the 19th.
Now you're repeating yourself. We understand.
So I believe that I have established a legal malpractice case here, and I believe the evidence is clear, and I believe that the ruling from the lower court is very flawed.
And you would like it to be reversed.
And I believe that it should be reversed and or sent to the lower court for a trial. And my argument is I believe that I have made my case for summary judgment on cross motion for my complaint to be granted.
Thank you.
Thank you.
Good morning. May it please the court. Tara Shortino on behalf of the defendants. Judge Montour, I'd like to respond to one of the questions that you asked about Mr. Tubiolo contacting the OPMC on the 19th. And the response was that call me after you have met with him. But also important is the email that was sent that day where Mr. Tubiolo advises the plaintiff, Mr. Green wants to meet with you first to explain to you that there are no guarantees. Additionally, I'd also like to address a couple of other points that were made. The statement that Mr. Tubiolo indicated, I always get an extension. The circumstances here were a little bit different. The parties acknowledge that it's common practice in law to get an extension to answer a pleading. Here we have the plaintiff proceeding pro se at a May 15th, 2014 hearing before the ALJ, where he was directed specifically by the ALJ and warned about the importance of the time frames and what would happen if an answer wasn't timely submitted. Here, the defendants have met their burden of proof through expert proof, demonstrating that they did not deviate from the standard of care, that there was no proximate causation, and that there was no damages. Unless your honors have any further questions, I can rest on my papers.
Thank you.
Thank you.
801, U.S. Bank National Association v. Patrick Eckert. Oh, come on up.
Patrick Hacker.
Yes.
Wait just a minute, then. Do we have everybody?
Yeah.
Okay. Okay.
Thank you for the opportunity to appear before you today. My name is Rick Goodell. I'm with Legal Assistance of Western New York, and we represent the defendant borrower in this appeal, a limited scope appeal, of a residential mortgage foreclosure case from the refusal of the lower court to grant any relief from the accumulation of interest, cost, and fees during an unreasonable delay caused by the plaintiff bank, material breach of its statutory duty under CPLR 3408 to negotiate in good faith while a residential foreclosure action is pending in the foreclosure settlement conference part.
There were 17 foreclosure settlement conferences, correct?
That's correct, and that's why our appeal is only a limited scope, and we're only focusing on the period of time after it's acknowledged by everybody that a complete loss mitigation application had been submitted by the defendant borrower, Mr. Ecker, and was in the hands of the bank, the plaintiff. And at that point in these negotiations, the next step is that the bank evaluates and provides a written response.
And they lost the application. Am I accurate on that?
Lord only knows what happened to it because it went for 5 months before COVID came, including 3 more or 4 by our count. There's one small factual dispute raised by the papers about when the application was complete.
But at the very latest, October 15th of
Correct.
2019?
So
the response is due under the regulations by November 14th.
That's correct. And I don't know that our Supreme Courts in these conferences are strictly enforcing that 30-day rule, but that is the federal regulation. And there's no question here that we blew through the October, November, December, and January conferences with no reaction at all. And in fact, there was a conference scheduled for, I think, the 18th of March of 2020. And there was an ongoing duty to respond to that application for the next 2 months, and they didn't. Now, that ended up being canceled. The second period...
That's probably around the date COVID hit. That's
Because-
probably around the date the courts closed. I think
That's
it's right
right.
around then.
That's right. And
But,
so
but you're saying it happened before anyway.
That's right. For 5 months, they'd done nothing at all. 6.5 by our count.
And you're only asking that the interest and penalties be, well, you tell me.
Be awarded for the period of time
Right.
before they got back on track.
Right.
So what happened next was the COVID epidemic, and I think they tried to assert that unless they had to go to a conference that was already scheduled, they didn't have to keep negotiating in good faith, and that's not the statute. The statute provides that you have a duty to negotiate in good faith as the plaintiff while the case is in that part. And for the next 18 months, they did nothing. Now, they tried to excuse that because of COVID, and they put in no factual allegations in their answering papers to our motion from the bank or anybody in the loan service or anything like that to say that they couldn't have evaluated the pending application and decided whether Mr. Ecker was eligible and responded. No factual allegations.
We'll look into all that. It's okay.
Thank you. On appeal, there's the discussion of judicial notice, and obviously, common man on the street isn't going to know whether banks could continue to do mortgage servicing during COVID. None of the executive orders or laws or rules applied to them. They were an essential business. They were always open. And in fact, there was a report by the regulatory body, the CFPB, that did an examination. They do audits, and they did an audit of 6 months of the COVID period from January to June of 2021. And they said the banks are not doing this within 30 days. They're supposed to be doing it. And the only reason they're not doing it, according to the CFPB, was because of lack of good faith. So there's no reason to believe that they couldn't have done something during that 18 months. The final 2 months were when we finally got back in conferences in September of 2021. The court said, well, we're going to have to do another application form because of the passage of time, provide one within a week. And the next conference was in November, I think the 17th, and they hadn't even provided the application form by then. So we're asking that the period go from either 1 month from September 3rd or 1 month from October 15th. That's a factual dispute in the papers through November 23rd when they finally were back on track. If there's any issue with respect to the timing of the motion, I just want to briefly address that point, if I may. There are some Second Department cases that say that they are going to assume without deciding that the statutory obligation to negotiate in good faith of the plaintiff can be enforced by motions made outside of when the case is still in the foreclosure settlement conference part. Now, of course, there's plenty of case law before some amendments in 2016 that sort of set up the structure to be able to do that during the foreclosure settlement conference with minimum mandatory penalties against the plaintiff, loss of interest, costs, and fees, in which the courts, whenever the motions were made, were granting relief from the interest, costs, and fees. In those cases in the second department, they say, we're going to assume without deciding that we can still enforce this breach of duty. And then the site of cases, if you look at the cases, for example, in Citibank.
You will look at the case.
Oh, okay.
I've looked at the case.
I beg your pardon. They previously were deciding those motions, and more recently they're saying, assuming without deciding whether, this court would have to decide that it can entertain a motion made after the foreclosure settlement conference part is over, but while the case is still pending. And we would suggest that certainly in this case it would be appropriate. Mr. Ecker did not have an attorney during this extended period of time. His only assistance that he ever got was from someone who worked for Stalk Opportunities, a nonprofit that helps people. She had left that organization in February of 2022 before our law firm was hired. So there was nobody involved in his case who had direct knowledge of what had happened to him before. When we got involved, we had a limited scope representation. We just wanted to keep the case in the foreclosure settlement conferences while he tried to work out other remedies. Ultimately, he borrowed money from an outside source. And it was only after the payment was made and we saw how substantial the interest charge was, spoke again with Ms. Cooper from Stalk Opportunities, that we brought the motion for relief from the interest that had accumulated during the unreasonable delay.
Can I ask you one question? Because my there's two different dates that we could start this at, and one is May 15th, and the other is November 14th.
We have completely dropped our argument that it goes all the way back to the first foreclosure settlement conference.
That it would be November 14th.
We would say that it begins 30 days after the application was complete, which is the day that the two documents that were requested, the missing documents, so-called, were provided. Our allegations are that they were done on the same day, September 3rd. Why have the client come in and sign a tax release form and not have him sign the hardship statement? But that's a factual issue.
I think we have that. Thank you.
May it please the court, Harold Leonard Kaufman, on behalf of the respondent, U.S. Bank. This is a case involving discretion, and the lower court properly exercised its discretion in denying appellant's motion. The lower court was on the ground. It was the entity that supervised the settlement conferences during the entire time, and it determined that there was no absence of good faith pursuant to CPLR 3408F. And we submit that that exercise of discretion was correct, and that there is no basis for this court to reverse the lower court's exercise of discretion. The record does not show an absence of good faith. The court has to look at the entire history of the settlement conferences, and when it does that, it will determine, we believe it must determine that there was no absence of good faith. There were numerous delays.
Mr. Kaufman.
No, I was saying, Counselor, you don't dispute what the appellant argued, though, correct, with the dates, as far as the submissions were not made when, right, those dates were not abided by, correct?
We do not, there's nothing in the record to dispute that there was no response from October 15th when we received this, or from November 15th, 30 days thereafter, until January 20th or 19th, 2022, or 2021 rather. There's nothing in the record that we can dispute that, but that is, in looking at good faith, that is a tiny wedge of time that, looking at the record as a whole, shows that there's no absence of good faith.
It seems to be beyond 30 days though, right?
We're not disputing that unfortunately it did not, we did not respond according to the record as promptly as we should, but the court has to look at the totality of the circumstances, not that one segment of time. And looking at the totality shows that we responded promptly to numerous requests. The court asked us to do something. We did it within 2 days. The court asked us to get missing document letters. We did it within a couple of days. The court
Mr. Kaufman, if you look at the factors under CPLR 3408, that's the totality of circumstances that you're referring to. We've got the failure to comply with the regulation for about 4 months between November 14th of 19 until the start of the pandemic. We can even ignore 18 months and just imagine that under the 18 months, your client is under no obligation for some reason, although frankly, I think that's in dispute and I don't think it's supportable. But even if we were to ignore that, we have a directive by the court, get the new LM packet to the defendants within a week in September. That wasn't done for 60 days. We have a violation of a directive of the court. Don't you acknowledge we've got some unreasonable delays here and several of these CPLR 3408 factors?
No, I don't. I think there is an issue as to the compliance starting on October 15th through January, but that is one segment. That is the only factor that's at work here. And
why do you say January and not March?
Because under CIT Bank, Deutsche Bank v. Singh, the only time that's relevant is at the conference. It is not following the conference. It is at the conference. If there had been an actual conference in March, that would be a relevant date, but it simply is not. We think CIT Bank or Deutsche Bank v. Singh on that point. And again, I look at circumstances, which is the entire period, which, yes, there were times where I think that we could have responded more promptly and should have responded more promptly. There were also times where appellant didn't provide information in a timely fashion, waited 2 or 3 months to get us a modification application, both in 2019 and again in 2020, late 2021. So looking at the totality, the entire period, it is clear that we entered into these settlement conferences with the intent of trying to reach an agreement. And ultimately, we did offer a modification agreement. There's no basis to argue that we entered into this in an absence of good faith and we're just stringing along the borrower. That is not what the record demonstrates. So
we'll look at all that very carefully.
Thank you very much. And if there's nothing else, I'll rest on my papers.
Thank you. 804, Jean Noddy, the County Line Stone Company, Inc. Hello, can you unmute yourself, please?
Good morning. May it please the court. My name is Alita Gaida. I'm here on behalf of the appellant, County Line Stone. As the court is aware, this is an appeal of a denial of a motion to dismiss on the complaint by the lower court. The complaint, which we are assuming all allegations are true for this appeal, alleges that water withdrawal and blasting from my client's facility located a mile away from the property caused cracking of the ground, damaged private water wells, and homes. We respectfully assert that the motion to dismiss should have been granted. We first look at the claim of our negligence claim. Our claim that negligence should have been dismissed as duplicative of the private nuisance claim. We urge this court to grant this relief. In Drake versus Village of Lima, the similarly was where the complaint itself is based on the same facts, alleges the same wrongs, and seeks the same damages in both causes of action. And that is what the complaint in this matter does as well. Here, the claims are identical.
Doesn't the private nuisance claim list or indicate that the acts were intentional versus the negligence claim, which obviously indicates that the removal of the water was negligent?
It does. However, with respect to duplicative claims, it is still the same facts. It still seeks the same damages. Each are based on the fact that there was water withdrawal and blasting that damaged the property, and caused
And the nuisance claim listed not only the water, the groundwater, but also the blasting. So there's making different allegations in each one.
Actually, if I may correct the court, both causes of action, negligence and private nuisance, allege that both blasting and water withdrawal caused the damages, and both seek damages of $1 million to plaintiff's homeland and personal property which have been damaged.
Let me correct myself. I think the negligence only related to the blasting, but the private nuisance related to the water and the blasting. So
if
both
items were mentioned in each. If you were to take a look at paragraphs 47 to 51 in record pages 9 and 10, and nuisance paragraphs 53 through 58 and 11. This is why we saw that there were duplicative claims here. This isn't an instance where negligence is related to one issue and private nuisance might have some overlap, but there are other issues. It's the same claim with the word duty not to cause harm replaced with intentionally caused harm.
Now,
we also,
if the invasion, though, is intentional, the WFE Ventures case speaks about if the actant here becomes aware that the conduct causing substantial interference and nevertheless continues to utilize it. And there's in the record, there's instances where your company has purchased 5 properties wherein it's purported that the reason for the purchase was the damage that was created by the blasting and or the removal of the water. So there was some knowledge on that part, but you continued to do so. That's the allegation on the nuisance claim where it was intentional.
So that is the next point that I wanted to raise. We believe that the allegations do not show that necessary intentionality with respect to water withdrawal, because they talk about the intentional act of withdrawing the water, but it doesn't, the pleadings themselves do not go far enough to say that they acted knowing that withdrawing the water 1 mile away from the plaintiff's property would cause harm to the plaintiff's property.
Well, the blasting too.
Yes, for the blasting, we do not have an objection on the private nuisance claim because that is, as a matter of law, as the court knows, a strict liability matter, which is pleaded, sufficient for that basis. But
This is a motion to dismiss as well, right? So we have to give the inferences and deference to the plaintiff, right?
We do. However, if the allegations are missing, then the court cannot supply them in their absence. And here we believe that the word intentional was used with respect to water withdrawal for private nuisance. However, it did not connect the intentionality of knowing your act would harm a property a mile away sufficiently to survive a motion to dismiss all the 4 corners.
Is that more related to your public nuisance claim?
Public nuisance, yes, the water well issue is very relevant for the public nuisance claim, which here, the opposing brief goes into some discussion of how the appellants seem to be arguing that only public lands are something that can be asserted for a public nuisance, and we obviously know that the law allows for public rights. We just assert that if authority wasn't provided that private water well could be the basis for a public nuisance claim. However, the opposing also mentions the study that was attached to the submission by the respondents below, noting that there was only one water well on the same street that was studied, and that was 10 years ago. However, if that's the case, if there's only one water well, it is not a public right because there's only one well that we're talking about.
Okay, we'll look at that very carefully.
All right, and I think just another couple points on that. They also failed to allege a considerable number of persons. However, should the court look to the report, it does discuss a number of wells. That would demonstrate that there is no special injury here because the respondents would be assuming that there are a number of wells that are all damaged. That's not a special injury for purposes of public nuisance. Finally, with the special injury, they also did not demonstrate that the damages to homes is different in kind, not merely degree. while they didn't raise the issue of condemnation below, the condemnation itself is evidence that the home is so damaged that they cannot use a portion of it. That means the damages are more severe, which not that they are different than other homes that the complaint clearly alleges were damaged. So similar to 532 Madison Avenue, there are no different damages that are different in degree. Different in kind, only damages that are different in degree. So with that, we believe that the public nuisance claim should be dismissed for special injury, as well as the points in our brief.
Thank you.
If there are any other questions, otherwise I can yield my time.
Thank you.
Good morning, and may it please the court. My name is Thomas Lyons from the law firm of Duke Holzman here on behalf of the plaintiff respondents, the Natty family, in connection with this matter. At its core, the quarry's motion was a pre-answer motion to dismiss, seeking to effectively cull the complaint down to the claims that the quarry wishes to defend against, not the claims that have been well pled in the complaint. To do that, the motion, which was a pre-answer motion to dismiss, effectively made three arguments, which you've already heard from Ms. Guida. First, that the negligence and private nuisance claims were duplicative. Judge Montour, I believe you've honed in directly on the issues here. There are different elements and different proof thresholds for those claims. There's also the fact that there are different damages. Nuisance claims themselves address property rights, whereas the negligence claim can encompass property rights, personal property, and others. We highlight that in our in our opposition brief, that the negligence claim has the ability to provide remedies that the nuisance claim cannot, and that in addition to the different evidentiary thresholds is why they're not duplicative. Second, the quarry's claim sought to, with regard to the private nuisance claim, presuming it prevailed and dismissing the negligence claim, sought to then cull down the actual allegations that were in the private nuisance claim to only the blasting. However, and we again highlight this in our brief, so I won't belabor it too much, but we argue that it is the combination of two actions conducted by the quarry, knowing that these actions had previously committed other damages to properties. Again, Judge Montour, you highlighted it. It is right in the complaint. It's paragraph specifically 30 to 45. That's record page 8 to 9. We highlight that there are prior damages and prior properties purchased by the quarry, and with the inferences afforded at the pre-answer stage, we submit that that is enough to allow that claim to survive with the allegations pled, not the culled down version, which would only leave us prosecuting a blasting case. We're not just prosecuting the blasting with regard to the nuisance. Finally, with regard to the public nuisance, Ms. Guida mentions that we failed in two respects. First, that we didn't allege a private right, and then second, that we didn't allege special damages. With regard to the private right is the water rights. We did allege that. It's in the complaint. We've also briefed it sufficiently. The right of the water wells for other properties all along Scribner Road in the town of Pembroke, which is where my client's property is located. There's the suggestion that those water wells, and the allegation in our complaint that those water wells have gone dry. The only item that she points to is a report from her own engineer, but that looked at data that was 10 years old, and more particularly, that is a fact issue that we can address in discovery and at summary judgment. With regard to the different damages, we've alleged that the water wells and right to access private water wells along a number of properties on Cohocton Road, Scribner Road, and others, affecting a number of residents, is the private right, and our damages are different in kind and degree because we didn't just lose access to water. My client's property was destroyed, and the land itself is effectively unusable, as noted by the condemnation component. I do want to note one thing, however. Ms. Guida noted in her argument that we didn't raise the condemnation issue below. That's simply not true. I will point, docket number 70 is our memorandum of law below. It's not part of the record on appeal, as is customary. However, we did raise the condemnation issue. And more importantly, it's cited in our complaint at paragraph 66. Pending any further questions from the court, that's all I've got.
Thank you very much.
Thank you.
805, in the matter of application of the state of New York versus Maui S. Okay, Mr. Brody, you're single today. Go ahead.
Understood. Am I on video and audio now?
Yes, you are.
Okay. May it please the court, Frederick Brody for the state. I understand that the appellant has submitted And I'm appearing today to ask if the court has any questions about this case, and to answer whatever questions the court may have. If the court has no questions, I'm prepared to submit as well.
I think we're good. Thank you very much.
Thank you, Your Honor.
806, and Thomas Toussaint versus Hamburg Overhead Door. And you're solo today as well.
Yes. Good morning. May it please the court. Matthew Rittenauer on behalf of the appellant J.M. Door Service. The appellant argues that on the motion below, J.M. Door Service established a prima facie case for summary judgment. We did that by putting forth the testimony of the door installer, David Gullen, from Wayne Dalton. The J.M. Door Service hired a very reputable local door installation company. Mr. Gullen had 21 years of experience installing.
I have a concern about Mr. Gullen's testimony in reading it, and it's about checking the door to see if it went up and down manually at the time it was installed. And for my testimony, I'm looking at 471 of the record. What did you do to test the operation of the door? This is after his installation. He says you run them up and down. When you say up and down, do you mean using the remote control with the electric opener? Yes. And did you also run them up and down using the chain fall? That would be when you pull the little chain. He says we did not run them up and down fully, but we did use a chain fall, yes. So one of the arguments we have in this case is that there wasn't proper testing of the door in the manual position at any time between the time of installation and the time of the accident, and that the accident might have been the first time somebody tried to operate the door manually. What do you have to say about that?
So when the door is operated on the chain fall, so the electric motor is disconnected, they pull a cable and they disconnect the electric motor. If the door is not controlled by the counterweight system,
right,
the door will immediately crash down. The chain fall will run and it will come down.
Yeah, you said that in the reply brief. I saw that under the correction section, and then I looked at the cites. You cited Mr. Migdal's testimony. So I went to Mr. Migdal's testimony, but that's not what he said. He didn't say that. He says you can disconnect the cable motor and bring the door down with the chain hoist, but not with the cable being off. He was talking about the cable being disconnected. That's not the issue.
Right.
Here we have the testimony is either no one knew or the plaintiff says the cable was still on. So we don't say that. I don't see anything in the record, unless you point to me something else, that says when that electric motor is on and working, that'll still operate that door up and down, even if the torsion isn't correct on the manual.
Okay, two separate things we're talking about, which is the confusion here. There was definitely testimony by Mr. Migdal that when the spring-loaded counterweight system is inoperable, that both the electric motor and the chain fall will not control the door.
Where? Where do you see it?
That's Mr. Migdal's testimony.
Yeah, 261. I went there. It's not there. I couldn't find it anywhere else in the record. I understand you're making that claim, and you have to make the claim. I just couldn't find it in the record.
Sure, and maybe there was the wrong site there, but I'm positive that Mr. Migdal did say that, and he was asked that question. And the court below even quoted that. The court below put that in their decision, that Mr. Migdal had said that. That was right in the court's decision. So the court below picked up on that also. The other question is, the first question that I thought you were asking me was about whether or not the door was properly tested. And when the door is in a partially open position and it's put on the chain fall, it's not gonna go up or down if the counterweight system is not operable. So they were able to tell that the counterweight system was operable. And when it's on the chain fall, if there is too much winding pressure on the springs, they're overly tightened, the door's going to rise on its own. If there's not enough, the door is going to fall on its own. It didn't do that. It didn't fall or it didn't rise on its own. And so...
Well, wait, but how do we know that? We don't know that until the day of the accident when it was stuck. That's the only time we know that it was ever tried to be run up and down manually. We don't have any idea whether or not it didn't. So it's stuck. Let's assume it's too loose, which is what the plaintiff's claim is. The plaintiff's expert claim is that the torsion isn't controlled properly, it's too loose, but the door is stuck on something. Who knows? It's been 7 months since the thing was installed. It's the middle of winter on December 26th. Once they free it, it falls. The door falls because it was never properly torsioned. That's the plaintiff's claim here, right?
The plaintiff's claim is a tough one here, because what the plaintiff is saying is that despite the testimony that the door would not respond to the chain fall or the electric motor if the counterweight system is inoperative, that at the time of the accident, what they're saying is that the counterweight system was inoperative in terms of what happened. And so if you look at what Mr. Phillips is saying.
Right, I'm at paragraph 11, 12, and 13 of the brief. He doesn't use inoperable. He says if the torsion springs are not wound enough. So it's not a light switch on, off, black, white, operable, inoperable question. It's a question of is it torsioned correctly? Is it just right? That sweet spot where you're right, where it won't go up on its own, but it'll come down easily when you pull it.
So we've got 7 months of use of the door in a busy municipal garage, day in and day out. It's being used. There's absolutely no indication anywhere. I mean, at the beginning, the door was tested somewhat by Mr. Gullen. To his satisfaction. It was looked at and it was tested by Mr. Migdal. And then it was turned over. The door was turned over to the county, and the county...
Migdal clear that he tested it in the manual mode? Is his testimony clear on that point?
Mr. Migdal...
You know I have it in front of me.
Yes, yes, no, and I think that Mr. Migdal did not say that he ran the chain up and down.
Right.
So why isn't that enough for a question of fact right there?
Because if the door wasn't set at the right tension, it would never have functioned for 7 months.
But that's when it's powered, and this is when the power is disconnected, so we have a different situation, don't we?
We don't, because the motor in this case, the motor that controls it is not designed. It won't raise and lower the door if the tension on the tension system is not right.
Where's the motor expert? I don't have an affidavit from a motor expert. I have Morrison's affidavit. He doesn't say anything about the motor being insufficient to raise the door if the counterweight system is working
Mr.
properly.
Migdal says that, Mr. Migdal says it, and Mr. Morrison agrees with him that it wouldn't do that. It would not, the motor is not capable of raising this door and lowering the door if the counterweight system is inoperable. So we know by the fact that this door was run for 7 months in the county garage, day in and day out, that it was, the counterweight system was working fine, and we didn't have an issue until that night. And
I think you've made that point.
And-
Do you
and
have
at-
anything further?
Yes, just briefly. It goes to this, segues, I think, into the point where whether or not, under the Espinal analysis, JM Door Service launched an instrument of harm. And you have two different analysis here, if you will, two different perspectives. One perspective is what happened with the door installer, Wayne Dalton. Did they launch an instrument of harm or not? Did they fail to tension the spring or not? And then you have the separate question of whether or not JM Door Service launched an instrument of harm somehow with their inspection of it. Was there something that they did that caused it to be any more dangerous than it was when Mr. Gullen says, "I'm finished with it"? And I don't think that there was. There really wasn't anything to suggest that JM Door Service is responsible for launching an instrument of harm. So even if you're concerned about the issue of did Gullen do his job or didn't Gullen do his job, you still, when it comes to JM Door Service, under the Espinal analysis, I think that there really isn't proof that they launched an instrument of harm. When you, if I skip down to the last thing, which is Judge Del Conte's order in this case, indicating that the plaintiff was to disclose what the specific defect in the door was, and whether or not that was prejudicial to JM Door Service. I think if you look at the respondent's brief, it highlights the problem that we're in. And the problem was, we had no specific defect to present to Stu Morrison to ask him to analyze. We had to make him go out and look at every single blessed thing that was done to try to anticipate what might be coming down the road. And lo and behold, we get on an appeal, and the respondent's brief says it was the set screws. There was loose set screws. They don't say anything about the spring tensioning in their brief. It seems like they changed it, or there was some kind of disconnect there. So that's the issue that was prejudicial to the JM Door Service here. We had no way, no ability of asking.
Okay, you've already made that point, and you should be wrapping up because your time's almost up.
Sure. There was testimony in the record by Mr. Migdal that he checked the set screws. They were wrench tight. The testimony of, the key testimony here, I think, that really resolves the whole thing and really segues back into whether or not we establish our prima facie case, was the examination of the door the next day by Mr. Migdal. The only thing wrong was a simple maintenance issue. The cable had become disconnected. And that cable becoming disconnected and the whole system working fine after it was reconnected really establishes that that was the only cause here. That was the only problem.
But Mr. Migdal testified with respect to reattaching the cable. I think maybe we backwound the spring to get the drum in the right position to do it. And doing it is reattaching the cable. So he did have to rewind that tension spring after the accident.
That's what you have to do, because once the cable comes off, the spring tension is lost.
Right, but to say all he did was put the cable back on the drum, that's not actually true. You do have to rewind that tension spring.
Right, but
Okay, I think we understand.
Okay, all right.
Thank you.
Thank you.
U.S. Bank National Association v. Randall Holmes. Okay, you're both here. You can begin.
Good morning, Your Honors. Margaret Casino for the appellant. The dismissal order should be reversed as the record is void of any documentary evidence supporting the trial court's determination that the mortgage debt was accelerated in December 2009. Although defendants filed 2 successive motions to dismiss, defendants failed to attach a copy of either a notice or a filed complaint establishing the date on which the underlying mortgage debt was accelerated. Therefore, there is no substantiation for the trial court's conclusion that the current action was time-barred and the dismissal order should be reversed. Here, the defendants filed 2 motions to dismiss. In their first motion to dismiss, defendants argued that the current action was barred by the doctrine of res judicata based upon a dismissal of the 2015 foreclosure action. However, the dismissal of the 2015 foreclosure action was dismissed by a judicial finding in 2016 that the lender lacked standing to commence the foreclosure action. The appellate authority, as we cited in our briefs, makes clear that a foreclosure action commenced by a party without standing is insufficient to accelerate a loan. While that motion was pending, defendants filed a second motion to dismiss. Again, defendants failed to provide any documentation to the trial court establishing that there was an acceleration of the mortgage debt in 2009. As the Court of Appeals stated in Albertina Realty Company versus Roseboro Realty Corp. In 1932, to trigger the statute of limitations, an election to accelerate the loan must be made by an unequivocal overt act. These principles were echoed by the Court of Appeals in its Freedom Mortgage Corp. Versus Engel decision. To the extent that defendants meant to argue that the filing of a 2009 foreclosure action constituted an acceleration of the debt, defendants failed to attach a copy of the filed complaint to conclusively establish that there was an unequivocal overt act of acceleration by the lender. While the filing of a foreclosure complaint could constitute such an overt act, the appellate precedent requires that such overt act be clear from the record before the trial court. And here, there is no documentation to support the trial court's determination that the mortgage debt was accelerated in December 2009. Even if this court were to determine that the 2009 foreclosure action somehow accelerated the mortgage debt, the 2009 foreclosure action was timely discontinued by the lender in 2013 within the 6-year statute of limitations period and in accordance with the laws that were in effect at the time of the voluntary discontinuance. These actions occurred more than a decade prior to the enactment of the Foreclosure Abuse Prevention Act. At the time of the voluntary discontinuance in 2013, it was well established that a lender may revoke its election to accelerate the mortgage through an affirmative act by the lender occurring within the statute of limitations period, provided that there is no change in the borrower's position in reliance therein. Here, the lender affirmatively revoked any prior acceleration through the voluntary discontinuance of the 2009 foreclosure action, and defendants did not argue that there was any material change in their position or reliance upon any alleged prior acceleration. Even this court in 1939, its decision Mahone versus Remington, held that the order discontinuing a prior action annulled all proceedings that had been had in connection therein and rendered the pleading ineffective. These principles in Mahone remained unchallenged until the Second Department rendered Christiana Trust versus Barua in 2020, in which the appellate division determined that a voluntary discontinuance by itself was insufficient to revoke an acceleration without something more. The voluntary discontinuance of the 2009 foreclosure action should only be reviewed in the context of the laws in existence at the time of the filing of the discontinuance in 2013, and not the body of case law that developed more than 5 years after the lender's actions were taken.
We'll look at that very carefully.
Thank you.
Any other arguments?
Yes. Secondly, even if this court were to determine that the trial court properly disregarded the 2013 deacceleration, the trial court erred in applying FAPA retroactively to this action. FAPA provides that it will take effect immediately and shall apply to all foreclosure actions in which a final judgment of foreclosure and sale has not been enforced. The Court of Appeals found that similar take effect immediately language was insufficient to apply statutory amendments retroactively. And it's long recognized in New York that statutes are generally applied prospectively in the absence of express or necessarily implied language allowing retroactive effect.
Okay, I'm going to warn you that you only have 5 minutes left, so.
Yeah, here the legislature did not indicate that the amendments would apply retroactively to invalidate foreclosure actions that were judicially concluded a decade prior to the enactment of FAPA, such as this one. A statute has retroactive effect if it impairs parties' rights that it possessed at the time it acted, as in this case, or increased a party's liability for past conduct, or imposed new duties with respect to rights or transactions that have already been completed. Here, a retroactive application of FAPA impairs appellant's substantive rights by preventing appellant from enforcing its rights under the note and the mortgage, so the presumption against retroactively is triggered. A retroactive application of the provisions of FAPA would eviscerate and eliminate the longstanding rights of lenders, including appellant, without notice or opportunity of such lenders to protect their contractual rights, leaving the lenders, including appellant, without a remedy or an ability to enforce its mortgage lien.
Do you have anything further?
Just to say that here, the trial court did not address the constitutionality of a retroactive application of FAPA. The retroactive application of FAPA as applied here violates the appellant's due process rights in that it eliminates the rights that were in effect at the time of the prior lender's actions, in this case, the 2013 discontinuance of the foreclosure, without any notice or opportunity to respondent to enforce its contractual rights. And therefore, FAPA unfairly denies appellant its foreclosure rights after the fact when it complied with and relied upon provisions of then existing laws.
Okay, thank you. Who's next? Mr. Ruby?
May it please the court, Mark Rube for the New York Attorney General. The Foreclosure Abuse Prevention Act is the latest of many responses by the state to abuses by the mortgage lending industry that arose during the mortgage foreclosure crisis. During that time, lenders often rushed to court with inadequate documentation and then, in order to avoid an adverse judgment, unilaterally dismissed their claims and purported to restart the statute of limitations, a procedural tactic not available to any other civil litigant. After the New York Court of Appeals approved of that practice in a new rule in Engel, the legislature quickly acted to confirm that mortgage lenders must play by the same rules as every other civil litigant. They cannot unilaterally restart the statute of limitations, and they must comply with the requirements of the General Obligations Law if they wish to reset the clock. The legislature intended FAPA to have retroactive effect. The first department has expressly held so. The second department has applied it retroactively, and there's no reason for this court to create a department split. The text.
Could you go to the issue about whether the defendants have met their initial burden?
So I am only, on behalf of the Attorney General, we are only taking a position on
the FAPA,
on the constitutionality of FAPA. We're not addressing any of the non-FAPA questions, which I believe Holmes's counsel will address.
Okay. Do you have anything further?
I'll just briefly say a few words about the due process argument, which is the only preserved one, and then I will rest unless there's any questions about the contracts or takings clause. Just on the due process clause, I would just point the court to the U.S. Supreme Court's decision in Chase Security Corp v. Donaldson, where a statute of limitations was changed during a pending litigation, and the court said that that went to a matter of remedy, not fundamental right. And so there's no vested right here, and in any event, the statute is rational because it responds to abusive practices in the mortgage lending industry, that they could restart the statute of limitations at any time that they choose to do so, a tactic not available to any other civil litigant, which burden the courts, burden homeowners, and burden the general public that relies on finality and closure in matters of title. Unless there's any further questions, we ask that you reject the appellant's constitutional challenges to FAPA.
Thank you very much.
Your Honors, good morning. May it please the court, Kyle DeDone on behalf of the respondents, Randall Holmes and Terry Mosher. As my colleagues have pointed out, the Foreclosure Abuse Prevention Act was enacted to avoid this exact abuse, resurrecting a mortgage foreclosure matter that was 7 years past its statute of limitations upon its filing in 2022. To the issue of the sufficiency of the motions and the nature in which the motions were filed, I would say that the trial court has broad discretion over its motion docket and properly conducted a hearing to determine the relief requested in defendant's initial motion and supplemental motion to dismiss. Now, there is no true dispute that there was a hearing on the first motion. At that motion, it was determined that there were additional issues, including statute of limitations, that needed supplemental briefing. That was a directive of the court for supplemental briefs to be submitted. During that time period, FAPA was enacted in December of 2022, As a result, a supplemental motion with notice to the plaintiff in this case was provided, which included a request for relief under 3211A5 for dismissal for statute of limitations purposes.
Do we need to get to the FAPA issue on this case if we decide the loan wasn't accelerated?
No, if there's no acceleration, then FAPA would not come into issue. But to your issue, to your question on acceleration, I submit that the sufficiency was met on the motion in that there's two actual items that were provided. One being the summons and complaint. There's an excerpt of the summons and complaint that was provided. And it is in the record at page 128. And it says, accordingly, plaintiff elects to call due the entire amount secured by the mortgage. According to the trial court's order, judicial notice was taken that the summons and complaint was filed.
Is it unequivocal, though, when you say intends to? Is that unequivocal?
It is when it's filed as part of the complaint, Your Honor, yes. It's part of the foreclosure complaint.
Was it judicial notice or was it attached to the motion?
The excerpt from the complaint was attached to the motion. The filing date of the complaint was taken judicial notice, and there is no dispute as to the filing date of the 2009 action, the December 1st filing date. Beyond that, we have also provided evidence of acceleration even earlier, 9/15 of 09, in which an acceleration letter was sent to the respondents. And in that, it does not have the tentative language, may, could, should, might. It specifically states, if you do not cure the default within the specified time period, your obligation for payment of the entire balance of the loan will be accelerated and become due payable immediately. If they do not make the payment within the 30-day threshold provided in the acceleration letter, it will be accelerated. There is no, may or might language. So for those two reasons, we believe that acceleration did take place into the 2009. In the 2009 action, there was a voluntary discontinuance. There was no court intervention. There was no agreement. There was no consent on behalf of the defendants. And therefore, under the FAPA regulations, that voluntary discontinuance is not sufficient to restart the statute of limitations, and they would have lapsed in 2015. Prior to the enactment of Engel, prior to the cases that are cited by the appellant in this situation, all of which are pre-Engel or rely on Engel. I submit that those cases should be should give way to the post-FAPA cases, specifically taking a look at CIT versus Breyer, coming out of the Second Department, in which the voluntary discontinuance of an action was held not sufficient to extend the statute of limitations.
Okay, we'll look at all that very carefully. Do you have anything further?
I also would note that the appellant has acknowledged the expiration of the statute of limitations by sending collection letters through its servicer, which specifically contain language acknowledging that the statute of limitations has run. In the record, page 111 through 118, you'll see the language provided in these notices that Celine Finance LP believes that the legal time limit, the statute of limitations for suing you to collect the statute, may have expired.
May have. That's the problem, may have.
But they believe.
And that's not an admission.
It is an admission when it's provided in a notice.
It might have expired, I don't know, may.
In the sense that if it has not expired, they have no obligation to provide that notice. So there certainly is an acknowledgement by providing it.
We're looking at the language where it says may, okay?
Okay.
Anything further? Because you should wrap up.
I think it's clear that FAPA overruled Engel. It clarifies that the statute of limitations was not reset, and that in this case the motion to dismiss was proper, and the respondent respectfully requests the trial court order be affirmed.
Thank you.
Thank you.
808, Leon Martin III, v. Kaleida Health. Okay, go ahead. Hello?
Am I on?
Go ahead.
Good morning, Your Honors. I'm Brian Fitzgerald. I represent the plaintiff appellant Leon Martin. Let me just spend 1 minute on some basic facts and then a couple of minutes on what I think is a pretty straightforward issue on this appeal. Leon Martin was hospitalized at Buffalo General with an infection in his leg. He was, after that was diagnosed, he was put in an isolation room. After several days, another patient was put in his room. And then a few days later, he was told an incident had occurred where that other patient had COVID. He was then tested the next day, and it turned out that he then had COVID. So we brought the lawsuit alleging negligence on the part of Buffalo General for having put that patient in his room. And
And
in,
we want discovery, and that's what we're here for.
and in defense, Buffalo General has asserted the immunity provisions that if they're treating a patient with COVID, they're immune from suit. So they actually raised the question as to the care and treatment of that other patient with respect to COVID. They raised that as a defense. And one wonders how they can do that if that record is confidential. How do they even know that? Now, we've cited some cases. There's a case directly, we believe, on point, matter of Williams, 3rd Department, 1967. There, the plaintiff contracted tuberculosis and wanted the records of another patient. The court ruled that the 4504 privilege was not subverted as long as the other patient's records were redacted of any patient identifying information. We've also set forth in our brief some provisions of HIPAA, which actually provide for a patient de-identification process, delete names, addresses, phone numbers, things like that. So HIPAA was enacted to protect patient confidentiality, but actually promulgated rules and regs where hospitals could do that by following those rules and regs so that confidential patient information was not disclosed.
Counselor, how does that happen here? Because in your tuberculosis case, I think it was a tuberculosis ward, wasn't it? And there were multiple patients. But here, it's clear who this individual is going to be. I mean, there's no hiding him. The person who was brought in with COVID. So
I'm sorry, Judge, I have a little trouble hearing your question. I'm sorry.
The tuberculosis case you cite, I think, was a tuberculosis ward. There were multiple patients. So you really weren't identifying who the person was. Here, you're going to know who the person is. So I'm just asking you how that would work in terms of confidentiality.
Well, we believe that if they simply redact any and all patient identifying info, there can't be any breach of the confidentiality privilege.
What are you looking for specifically?
Well, we need to know when that other patient was diagnosed with COVID. Was it after he was put in the room? And therefore, Buffalo General would argue they didn't know or should not have known that he had COVID, and that would be a defense. But if he's diagnosed with COVID before he's put in Leon's room, then an argument could be made they knew that and shouldn't have done that.
So that's your main argument. That's why you want it. You want to find out if they knew what they knew before they put him in the room, correct?
That's right. And then who? So there's a note in Leon's record that he was exposed to COVID because this other patient was put in his room who had tested positive for COVID. That's in the record.
Right, and you just want to know when they were aware of it. That's what you're trying to
Yeah,
find.
and I have the name of somebody who authored that note. I think a Dr. Chris Conan. So this is what I'm looking at. If I now take the testimony of that doctor and I ask questions about that patient, I'm gonna run up against this privilege. I won't be able to get answers to those questions either during discovery. So clean up the record, redact any patient information out of the record. I can see when he was tested. Well, hopefully I'll be able to see when that patient was tested for COVID, who knew of it, who decided to put that patient in Leon's room.
I
So
think
can
we
get-
have that. Do you have anything further?
No, I don't, Your Honor, and thank you.
Thank you.
May it please the court, Molly McGorry with Connors LLP on behalf of respondents, Kaleida Health doing business as Buffalo General Medical Center. Kaleida Health as a hospital has a statutory, regulatory, common law duty and obligation not to disclose a patient's medical records. I think we can all agree to that. And here we have one patient, a roommate of the plaintiff, Leon Martin, and they're seeking disclosure of his entire medical record. And they say, oh, you know,
Well,
you
if they
can just...
redact the name and any other identifying information, what's the issue there?
Well, Judge Montreux, it's really not quite that simple, and I think that the regulations in HIPAA, looking at them...
It would show that, it would support the basis of Mr. Fitzgerald's claim that there was some sort of negligence, maybe gross negligence on the part of the hospital in permitting a person who's been apparently diagnosed with COVID and placed him in another room with a person who doesn't have it.
Well, Judge, I think there are a couple of issues with that. First, in terms of the facts of the case...
Wouldn't that be material and necessary for Mr. Fitzgerald's claim?
I don't believe that it is, and even...
How would he ever know until he finds out if the other patient that was placed in that room, whether or not that patient had been tested and they knew that he had COVID before they put him in the room? Where is he supposed to go with this? He needs to know that information. That's pretty basic.
Well, Judge, the problem with that is that that information is privileged. You're asking for a...
But if everything's redacted, I guess I'm having trouble.
Sure, and so if you look at the requirements for redaction, it's not as simple as redacting the patient's name and the patient's date of birth. The entire medical record would need to be reviewed to take out, I think there are 18 different pieces of information, and the hospital would need to have a person review that record and be able to say there is no way that somebody could, taking this medical record altogether, be able to identify who this patient is. And we have the additional problem that I think Justice Greenwood identified. This was a roommate. This was a one person, a roommate of Mr. Martin. And they were together in a room for a number of days. Mr. Martin indicated at his deposition, which was subsequent to this appeal, that he knew that the roommate knew his brother in some way. So this isn't some random assortment of patients who we have no reason to believe could be identified. We have a patient who Mr. Martin spent a great deal of time next to. So I think...
That's the problem, isn't it?
Well, Justice Smith, it's also not accurate to say that anybody told Mr. Martin that he was exposed to COVID from this roommate. Someone came into Mr. Martin's room and said, something occurred and you have been exposed to COVID, and several of the other staff members have been exposed to COVID.
Right, but the only way to rule out his roommate is by giving the records, right?
He presumed that it was the roommate. And so we're sort of leaping to various conclusions here and saying that, well, it must have been the roommate, and that Kaleida Health...
The reason they want the discovery is to find out whether or not it was a roommate. When was this person diagnosed? When did the hospital know? And when did and then put him in the room?
Right, Judge, but the information is privileged. Kaleida Health can't simply give that information, give an entire medical record to somebody who, without that patient's knowledge, without that patient's consent. And I think the Dillenbeck versus Hess case, the Court of Appeals case that the Fourth Department has reiterated, this court has reiterated, that it's inherent in the very nature of a privilege that it's going to present an obstacle to discovery. That's what a privilege does. And it's in precisely those situations where confidential information is sought in advancing a claim that that privilege is intended to operate. This court said the same thing in the PASA case in 2018, that information which is privileged is not subject to disclosure, no matter how strong the showing of need or relevancy. And I think here there's a very real risk that this patient's identity is also going to become known either from the medical
Okay, you made
records
that
themselves or
point.
the combination of that.
Okay, I think we have your argument. Do you have anything further?
Not unless there are any other questions, Judge. Thank you.
Thank you. 809, Bacon versus Schultz Management Group. Oh, and Justice Kane is accused on this matter? Wish I could get my voice back. Go ahead.
Oh, I'm sorry, I thought I saw counsel for Kessler was going to be remote, that's why I was pausing.
No, it looks like they've submitted.
Oh, he submitted, okay, thank you. Good morning, Your Honors.
Actually, it's afternoon now.
Oh, it is afternoon? Okay, I was checking the clock earlier, my apologies. Mark Colasano from the law firm of Kenny, Shelton, Liptak, Noack, on behalf of the appellant, Alstrom Schaefer Electric Corporation. Our appeal basically rises and falls on the court finding and reversing the lower court that this string, rope, or wire, whatever you want to call it, was not caused by Alstrom Schaefer. Unfortunately, the trial court seemed to mix up all the facts and said that there was confusing testimony. The fact of the matter is the testimony was very clear. That day of the accident, Mr. Sandberg said that he did not put the string on that door. He doesn't know who put it.
Well, isn't that your problem, though? Because he couldn't say unequivocally that there was nobody else from your client's company that might have put it there.
But they were talking about that in general terms at the site over the course of the project. The day of the accident, November 11th, he was the only one on site. And when you look at the testimony of Mr. Bacon in particular, he doesn't see the string on the door when he arrives at 8 o'clock in the morning and has no recollection of a string being on the door when he exited and entered 3 times during the course of the day.
When he was taking his 3 smoke breaks?
Yeah. And Mr. Gem, Kessel's project super, he doesn't know who put the string on the door. So our point is, my client, on behalf of our summary judgment motion, came forth and said, I didn't do it. Now it's incumbent for the plaintiff and the co-defendants to bring evidence that would create an issue of fact, and none of them do, because there's no testimony. Nobody knows who put the string on the door, or the rope, or the wire, as Judge Hanlon refers to it. So unless you have some proof as to my client's creating this condition.
Isn't there testimony that there's only one source of that particular string, only one?
That's correct.
So was-
My client, as the electrician, uses pull string.
Yes.
We had pull string on the site. But just because it was on site doesn't mean that my client used it. And as a matter of fact, Mr. Gem from Kessel, the GC, said that that door was left in an open position during the course of the project because the other trades had to go in and out bringing their equipment and material so that the door wasn't damaged. So it existed for 10 days, and then on the date of, somehow it ends up on this door again, but nobody knows who put it there. And that's our position. There's no evidence that my client did that. And if the court agrees with that and reverses the lower court, then there's no duty under Espinal because we didn't create the condition. And counsel for the plaintiff did not oppose on the grounds of detrimental reliance or that my client replaced essentially Kessel for safety on the site. We know that that's not the case because Kessel's witness, Mr. Gem, said he was responsible for safety. So if there's no duty, then the negligence claim obviously falls, as well as the Labor Law 200 claim, which was never opposed. And when you get to the Labor Law 241-6 claim, there's no evidence that we were directing and controlling Mr. Bacon's work. And that claim, when we moved, was not opposed by counsel for Mr. Bacon or by Kessel at the motion level, although Kessel's counsel in the appeal raises for the first time that it should be denied. So I think when you take all of the testimony, you find that there's no evidence we caused and created the condition for any of those causes of action to survive.
Are you done?
I was just going to make one point. I know it's a minor point in the grand scheme of things as to the spoliation. And the court did find that the evidence was spoiled, but wasn't willing to assess a penalty against the plaintiff or even Kessel. Now, I'm not suggesting that the case be dismissed. I don't think it was egregious, but they certainly disposed of it. And now we have the court saying wire, Mr. Bacon saying rope, and then Mr. Gem saying string. Well, without the evidence, that item, I don't know what we're dealing with, other than the testimony being all over the place in that regard. So we would ask that the court reverse the lower court and dismiss the action against Alstrom, as well as dismissing the contractual indemnity claim, because that rides on negligence as well, and any common law contribution indemnity claim by Kessel and Schultz. Thank you.
Good afternoon, Your Honors. Brian Toohey on behalf of the respondents, plaintiffs Floyd and Shelley Bacon. I almost followed in suit with my co-respondents and submitted. I think this is a pretty straightforward issue. Circumstantial evidence here is pretty clear. Multiple individuals from other subcontractors, Mr. Gem from the general contractor, they all identified this blue and white electrician's pull string as having been tied to the door string or door handle for approximately 2 weeks prior to the plaintiff's accident. Ample testimony that nobody else on this site had electrician's pull string except for the electricians. The circumstantial evidence does it allow us to reasonably infer that the source of the injury producing hazard were the electricians, the only individuals who had this electrician's pull string that were there? I believe that yes, it does. I think that this is exactly on point with multiple other Fourth Department cases that have been decided in this same realm on common law negligence claims against other subcontractors, specifically that was pointed out in our brief, Severino versus Whole Industries and Krajnik versus Forbes Homes. These were both cases that rested on circumstantial evidence. Nobody had any direct proof that this defendant subcontractor had left the injury-producing hazard or created the injury-producing hazard that the plaintiff was saying was the cause of his injuries. So we believe that everything that's in our brief provides us with the facts necessary to get an issue that goes in front of a jury. A jury needs to decide, or was Alstrom the cause of the injury-producing hazard in this case? If there's any questions from the justices?
Thank you.
Thank you, Your Honors.
811, Mark Ostrander, v. Aaron Mullen. Oh, we have to wait anyway. There she is. Good afternoon. You need to.
Thank you, Your Honor.
Perfect, great, thank you. Go ahead.
Can you hear me all right?
Yes, we can, thank you.
Great, thank you very much. Paul Argenteri for the appellants. Mark and Cynthia Ostrander. Respectfully, Your Honors, I'd like to have the case remanded back for trial. But I have to state on the record immediately that there's a problem in their counterstatement of facts before this panel on page 3. where they've stated as a fact that Towner created an abstract, or Empire Abstract created an abstract of title to verify the chain of title to the Two Rod Road. Those
Mr.
are two.
Terry, I saw your argument regarding that, and I have questions about it. I suspect that the answer, since it's always referred to as something created by Empire State Abstract, we have this 2-page letter from Paul Silva to Terry Towner in the record, pages 117, 118 of the record, and I think there was a map attached to it, and the map is, I think, similar to maybe your first map that you have in the brief that you had done, but I think that your position is that this doesn't qualify as an abstractive title. And there is some details in this letter about the research that was done, and I agree with you that it's brief and that I've seen abstracts that are far more extensive than this. But you tell me, why is this insufficient?
Well, if I could, since I've had the case since March of 2016, Paul Silva wrote a letter. First of all, I know who Paul Silva is. I mean, I practice law primarily in Steuben County, but I've tried cases over to Western New York. Paul Silva is the president of Empire State Abstract. The Ostrander's chain of title come from the Empire State Abstract Corporation. So when Mr. Towner was asking him to do some research on access, that issue was foreclosed by Paul Silva, stating there wasn't any access. However, when we got to trial that began in 2017, this is where the distinction with the difference came in. They attempted to produce a document from Empire Abstract stating it was verifying this falsified deed as a chain of title to the Two Rod Road. That's not true. There wasn't any document produced. In fact, if you look at Judge Latham's decisions, there's nothing in there that the Towner produced an abstracted title to a falsely created deed and renaming it falsely to a Two Rod Road.
So just so that I'm clear, when Attorney Moore was referring in the record to an abstractive title, and it's in the transcript, it's in a couple places in the transcript, your position is that he was referring to a different document that is not in the record, not the Silva letter.
That's right. The Paul Silva letter, first of all, Paul Silva, when he testified, basically won the case for us. So they produced a witness that verified not only the Ostrander title, but he verified that this 1883 transfer of title from McChesney to Perkins in 1883 was in point of fact in the Ostrander title for over 100 years. So I have no idea why Mr. Moore would produce a witness that verified not only our title, but totally refuted any attempt by them. They produced a document that they claimed was an abstracted title, but so when they say they verified the chain of title to the Two Rod Road, that's a total falsehood. There's nothing in the record. The problem we have with the case, that's why we had to make a leave to amend the complaint, because we have so many. God, I'm trying to be polite here. We had so many falsehoods presented in the case, it was difficult to just isolate them all in sequence. But Paul Silva did so much damage to their case. The case should have ended there with Judge Latham. And what happened was, until after the third day in trial, oh, by the way, on the record, before we even had the trial, we offered Mr. Towner access on 2 separate occasions. That was denied. And Judge Latham, off the record, told us to offer him access. He refused. So this is all before the letters were produced, and we couldn't figure out how this deed was created. And until we subpoenaed the first attorney, Attorney Mullen, and Attorney Plaskoff, incredibly enough, Attorney Plaskoff, as the attorney, had authorized the title of Ostranders for 10 years before the litigation. And then he becomes of counsel with the law firm suing the Ostranders over title.
We understand all that.
Okay, fine. So when they got subpoenaed, and they had to testify. Then we got the document dump. And in that document dump were the letters of December 10th, December 13th. And if you look at those letters, we have the authentic description, which is basically like a postcard. In that description, it just says 2-rod strip of land. Mr. Towner, who I'm going to flat out tell you had more skill level than most attorneys on preparing and reading an abstract, a survey, litigation. So at that point in time, Judge Latham finally realized, wait a minute, you're producing it. In fact, in his decision.
Wait, just a minute. I think you're kind of jumping the gun here.
Or I'm jumping
Going
over.
further than you should. You shouldn't tell us what Judge Latham was thinking. You don't know that. So let's just stick to your argument, okay?
Okay, well, okay. So we went on summary judgment in the decision. Now, we made 3 summary judgment motions. So before the trial, first time I ever met Mr. Moore, I said, there's something wrong with this case. So I've had adverse possession trials before. There's something wrong with this case. There's something wrong with your deed. Then in the middle of the trial, we made a summary judgment motion. Both those were denied. But at the end of the case, our summary judgment motion was granted, which means there was never any issue of fact.
Well, wait a minute, don't say that. Again, let's just stick to.
I guess I don't know how to say it. There was never an abstract of title verifying anything that Mr. Towner created. He purported to create an abstract of title. He had Empire Abstract devise some sort of convoluted.
Again, I'm going to ask that you wrap up.
Excuse me?
I'm going to ask that you wrap up because your time is just about.
Oh, wrap up? Oh, well, I believe in the interest of justice that we should have the case remanded. There's no question there's multiple deceptions, attorney deceit in this case that began with Attorney Mullen, went to Attorney Moore. Attorney Moore amended the complaint. Attorney
We
Moore.
understand all that. So what are you asking?
I'm asking the court to reinstate the case back to the lower court, to our ability to amend the complaint so we can add on even more deceptions and
Okay, I think we understand. Thank you.
I'm sorry. All right, thanks.
Good afternoon. May it please the court, Megan Brown on behalf of the respondent, attorney Scott Moore, and he's here today. Quite simply, the trial court got this correct, and the order that dismissed the complaint against Attorney Moore should be affirmed. There can be no attorney deceit without a false statement, and the Court of Appeals just reiterated that in the Urias case earlier this year. And the whole false statement on which the plaintiffs build this house of cards is this deed. And there's no finding or determination that this deed is a false statement. It was heavily litigated.
But in
Yes,
Urias, the court didn't require conclusive proof. You don't find that in Urias. They instead asked that the plaintiff simply identify a material issue of fact. And the plaintiff couldn't do that in Urias. So Urias is distinguishable with respect to the demands that weren't placed at the outset of the litigation that were placed, it looks like, on the plaintiff here, where the court was now looking for conclusive proof that Attorney Moore acted with deceit. We have allegations that Attorney Moore acted with deceit, primarily because of this claim that there's an abstract of title, which I still haven't seen. And then also claims that he knew full well that this bachelor deed was a fraud, but didn't present it as a fraud and went through 2 full actions, one of which he disclosed documents very, very late in the game. So those are the claims that are out there.
Sure.
Tell me first about the abstract of title.
Well, I think, and to the extent, if my brief made it more confusing, I apologize for that. I was adopting certainly the language from the motion papers, and I think it was, can I refer to an abstract of title described sort of abstractly? I think that's kind of what we had. It was commonly understood to be or taken as an abstract of title if it didn't exactly comport with what you might expect from an abstract of title. I think that that's kind of neither here nor there in terms of evaluating whether this complaint stated a cause of action against Attorney Moore, because he was not there's no intent. That's just a conclusory assertion. There's no intent, and there's no deceit where there's no false statement. There's a conclusory assertion of a false statement, but of a heavily litigated underlying document that no court came out and said this is a false statement. There's no finding of fraud, and I think it really puts it in line with the Facebook case that we discussed.
Wait a minute, though. But we have this argument that there was a false deed created. I mean, there's no doubt that that's the argument.
That's the argument, right.
And we have, in response to the argument, an attorney telling the court, Judge, don't worry, there's not a false deed. We have an abstract of title. And now you just explained what an abstract of title is in some way that I can't put my finger on at all. So why don't we at least have an issue of fact that that statement by the attorney was a misrepresentation, misrepresented the court?
Well, I would think even if that was a misrepresentation to the court, it doesn't rise to the level of a 487 action under any of the cases that we've relied on, under any of the cases that the plaintiffs relied on either, where those were actual state falsehoods that were put forth to the court. If it was a inartfully argued position, or, I mean, the cases are very clear that if you take a position in advocacy that turns out to be incorrect, that doesn't rise to the level of 487, it's supposed to be a strictly applied provision. You can't just say, I think this deed, what we have here is an attorney saying, I think this deed was false, and I told you I thought it was false, and you litigated it anyway, and therefore you should be sanctioned under 487.
But it's more than that. I mean, you have a deed that says there's an old town line.
Sure.
Not the new town line that we all know and love. It's the old town line. And then you have a letter from Mr. Silva, the president of the abstract company, saying there is no old town line, that doesn't exist. Unfortunately, I think Mr. Silva used the word unfortunately in that letter that we were talking about. Unfortunately, it doesn't reach your property line. That's the end of the analysis. But so at what point does an attorney have to go to their client and say, gee, you hand me this deed that references an old town line. I can't find any reference to an old town line at all. Is the attorney obligated to then say, well, you say it exists, so I'm going to go in court and say it exists? Doesn't an attorney have to act with some scrutiny of their own client?
Sure, I mean, of course, but I think here where the underlying authenticity of the underlying document was heavily litigated, we can't then say that there was an intent to perpetrate a fraud or advance a deceit or adopt a deceit on the court, where even the court that evaluated this deed didn't grant the motion to expunge it, didn't determine that it was false.
But the claim is for attorney's fees, and the disclosure of a lot of the critical documents, this document dump, was 3 years after the response was given in 2014 to the discovery. And we had all this litigation. 3 years later, we get this document dump, and the plaintiffs say that, gee, if we had that, we would have successfully moved to dismiss 3 years ago. We would have saved all these attorney's fees. Well, so that's the claim, essentially. What about that? The failure to disclose? I
don't think it was a failure to disclose, and I think in response to that disclosure, the response was thanks for providing that, or whatever. That's in the record. Certainly, Attorney Moore took over the case from somebody else. There's always a, transferring of files and finding things, and when you don't have the case from the beginning, you might not have your hands on everything or know where it is or obtain it later. I mean, I can't speak to the reasoning, but I think to say that would have conclusively resulted in something different. I mean, the Ostranders ultimately prevailed anyway.
But Mr. Moore still has that argument. Mr. Moore can still say at trial, if this goes forward, Mullen didn't give me these documents until the third day of trial. He didn't give them to me in 2014. He gave them to me in 2017, and that's a terrific defense. But we don't have that yet, do we?
We don't have that yet, but I don't think we need it because of the failure of the intent, which is conclusorily pled, and the failure of the false statement, which is not existent. If the false statement is the deed, and we don't know that the deed is even false, this puts it right in line with that Facebook case.
But Counselor, isn't one of your problems here that the court applied the wrong standard here? They said there was no conclusive proof of fraud by Towner that would have rendered Moore's representation deceptive. And that's not, it's not conclusive proof. There just has to be a showing that Mr. Moore knew there any allegation that at this stage of the proceeding. That's all we're talking about.
Well, the complaint has attached to it a bunch of documentary evidence, so we know in evaluating a motion to dismiss when it's supported by, when there's documentary evidence and not just the four corners of the complaint, that you have to look at whether the plaintiff has a cause of action, not whether they've stated one. And it's my position and my client's position that the documentary evidence attached to that complaint establishes that he doesn't have a cause of action, because it refutes this concept of a false statement, and it certainly refutes then an intent to adopt a deceit.
Thank you.
Oh, thank you.